In the more distant past, unpopular causes have involved representing communists, racial minorities, individuals who have sought to avoid the draft and so on. Indeed, I can remember as an article clerk in 1972 instructing barristers in conscientious objection cases under the National Service Act. It's hard to believe that that's still within one lifetime. Within each community and in every era, the unpopular causes somehow or other ended up being intertwined in the defence of an individual before a criminal court. An example of a lawyer who made a career of defending individuals who represented the unpopular causes of their day is, of course, the famous American Clarence Darrow. Clarence Darrow is probably the most famous defence lawyer of all times, not only because he was immortalised by Spencer Tracy in the film Inherit the Wind. And a close second, you might think, was Gregory Peck in To Kill a Mockingbird, and coming a distant third was perhaps the man who said it never seemed to me to lose a case, Perry Mason. Darrow's clients ranged from communists to teachers who taught evolution in school, but most frequently he fought the cause of racial justice. For example, in 1925-1926, in the Sweets case, Darrow fought against segregation and intolerance when he represented 11 members of the Sweets household who had reacted with force against a white mob trying to evict them from their home in a white neighbourhood in Detroit, killing one man. In the course of that case, he said, quote, "I believe the life of the Negro race has been a life of tragedy, of injustice, of oppression. The law has made him equal, but man has not. And after all, the last analysis is, what has man done, and not what has the law done," unquote. Those observations were made by him in his closing address in the murder trial in April 1926. And you might think in 1926 they were pretty brave notions to be putting into the American community. Most famously, of course, Clarence Darrow defended John Scopes, the Tennessee teacher who was in 1925 charged with the offence that arose from his teaching of the theory of evolution. That case became, as much as anything else, about whether the laws which prohibited the teaching of evolution were constitutional or unconstitutional. He is said to have told the jury during the course of that case that, quote, "The pursuit of truth will set you free, even if you never catch up with it." He also suggested, quote, "Laws should be like clothes. They should fit the people they serve." Another example of a great criminal defence lawyer in American history who took on an unpopular cause, or a number of unpopular causes, was Samuel Lubitz. Lubitz was a New Yorker and a Jew who came to Alabama during the 1930s to defend 9 young black men known as the Scottsboro Boys. Their alleged crime was the rape of 2 white women. In those days, black men accused of rape of white women rarely made it to trial. They were often lynched beforehand. These defendants are now conceded to have been innocent. Lubitz attacked Southern prejudices, such as the systematic exclusion of blacks from grand juries, and ultimately prevented the execution of all of his clients, even winning freedom from some. Back in Victoria, there are, of course, now and always have been, a significant array of criminal defence lawyers, far too numerous to mention. Because I've known him all my life at the bar, I can't help but at least mention in passing Robert Richter, a very well-known criminal defence lawyer. But Robert doesn't need me to tell you what a great barrister he is, and his record speaks for itself. I've already mentioned Frank Vincent, but I want to come back to another aspect of his career, and that of his personal friend and later judicial colleague, John Calvary. As I think I might have said earlier, Frank Vincent was appointed to the Supreme Court in May 1985, 23 years ago. At one point during his career at the bar, he left the bar in 1974 to work as a solicitor for the Victorian Aboriginal Legal Service. In the second half of that decade, after he'd returned to the bar, he and Calvary committed themselves to the defence of many Aboriginals in the Northern Territory. It was a shock to the system up there because the authorities were simply not used to these fellows being defended. John Calvary also served as a judge of the Victorian Supreme Court He was appointed in 1991, and as I may have mentioned, he retired earlier this year. One such case that they were both involved in, which I commend to those who are inclined to read law reports in their recreational hours. It's a much better read than Rowlands and Fletcher, I can tell you. Is a case of Collins and the Queen, 1980, 31 Australian Law Reports at page 257. In that case, Calvary represented a 13-year-old Aboriginal accused named Stewart. Vincent represented another accused named Williams. Dyson Hall Lacey represented the accused Woods, and one of the leaders of the criminal bar of the day, Mr W.M.R. Kelly QC, represented Collins. The charges arose out of the death of an individual at Huckata Station on New Year's Eve 1978 and involved murder charges brought against 4 Aboriginal boys aged between 12 and 18 years. During the course of the investigation into the murder, the accused had made confessions by taking part in a reenactment of the killing. At trial in the Supreme Court of the Northern Territory, the accused submitted that the reenactment material was not voluntary, or if it was voluntary, then it had been obtained by the use of unfair and improper methods and should be excluded in exercise of the court's discretion to ensure the fair trial of the accused. Calvary and Vincent were ultimately unsuccessful in their efforts to exclude this evidence at trial and also on appeal to the full federal court. However, the argument they fashioned had the approval of an important judicial figure, then Federal Court Justice Gerard Brennan, later Chief Justice of the High Court. He dissented, and that case and Justice Brennan's dissenting judgment came to represent an important precedent on the issue of voluntariness. Justice Brennan, in dealing with the circumstances, noted that each of the accused was a child or had a childlike mentality, and they came from an environment where Aboriginal children were scared simply by the arrival of a police vehicle. They were, as he described them, puny by comparison with the large police officers, and, quote, the power of the police was manifest from the first moment of contact, unquote. The judgment led to a clarification by the High Court of the principles involving the discretionary exclusion of voluntary confessions in the later case of Cleland. In 1984, Calvary was appointed as the Victorian Director of Public Prosecutions. He brought with him his concerns for the rights for suspected individuals in police custody, derived both from Collins' case and his earlier role as junior counsel assisting the Beach inquiry into allegations against members of the Victoria Police in 1975-1976. As Director of Public Prosecutions, he chaired the Victorian Consultative Committee on Police Powers of Investigation, which for a time I participated in. The committee is generally known and best known as the Calvary Committee. Most notably, the committee recommended, among other things, that which is now law in Victoria, that before an admission by an accused can be admitted into evidence, it must be electronically recorded. Unsigned, unadopted confessions by suspects related by police officers to a court were no longer acceptable. So it was intended the era of the police verbal would end. So while human rights advocacy may begin as an unexpected consequence of simply being a criminal defence lawyer, as you can see, it can in some cases almost inevitably lead criminal defence lawyers into different areas. Political, diplomatic, maybe even international in some cases. Because of the inherent human rights aspect of their work, some criminal defence lawyers have become leading human rights advocates because they have seen and understood what is at stake. Criminal defence lawyers, particularly when they become an icon for a particular cause, can, like other human rights defenders, be exposed to criticism and even to violence. For example, Hina Jilani, the former Special Representative of the United Nations Secretary-General on Human Rights Defenders, reported in 2004 that about 10% of cases she considered where human rights defenders had had their own rights violated because of their work involved lawyers who were targeted in their professional capacity. She reported that lawyers have faced disciplinary proceedings from their professional boards, have been sanctioned and at times have been disbarred and had their licences taken away for offering legal counsel. She reported that some have lost their jobs in connection with their action in the defence of human rights. while lawyers are relatively free to take up unpopular causes in Australia without reprisal, we should not be too patronising about this, because there have been some examples even here where lawyers have been vilified for their role in defending human rights. I come back to Phil-Apos. In his autobiography, which I referred to earlier, Apos describes the effect that his involvement in the Ryan case had on him, both personally and professionally. Quote, "The death of the unfortunate Ronald Ryan affected me deeply. It certainly changed my life. Before the trial, Sir Arthur Ryder had informed me that with the next vacancy occurring on the Supreme Court, I would be appointed to fill it. After I'd done my utmost to thwart the intention of the government to hang my client, I walked into the bar of Menzies Hotel to be greeted by Ryder, glass in hand, with, quote, 'Apos, so long as I'm Attorney General, you will never get another brief from the Crown. And as for the bench, you'd better pick one out in the Fitzroy Gardens,' unquote. I left without a word. The reaction did not end there. When at the Attorney General's direction the public solicitor was compelled to withdraw my brief so that Ryan could be hanged before his appeal to the Privy Council could be heard, I sought the advice of the Ethics Committee of the Bar Council. I wanted to know whether there was any objection to me seeking, through the media, a solicitor prepared to brief me free of charge on the basis that I declined any fee for myself and was prepared to pay my own fare to England as well as necessary accommodation and other expenses. I was told that I could not do so because that would be unprofessional conduct amounting to touting for business. I remonstrated, pointing out that a man's life was at stake and I would certainly not profit financially. The committee remained adamant. I defied the ruling," unquote. As he describes later in the book, he made the appearance on television and spoke on radio. He attacked the government for being callous and ignoring basic principles of justice in refusing a condemned man every avenue of appeal and removing from him the right to legal aid. He stated that he was prepared to offer his services free, provided that a solicitor was prepared to act for Ryan and brief him. After Ryan's execution, Apos was called upon by the Bar Council to show cause why he shouldn't be struck off the roll of counsel for his action. He describes being so physically and emotionally drained by his ordeal that he decided not to defend himself, yet his friends made arrangements for his representation. He later justified his actions by stating that he had done nothing except pursue what I believe was my appropriate course. He went on to say, "I was acting for a client in an unpopular cause. He was entitled to be represented, and it so happened that I was his representative. There was nothing I did throughout the association with Ryan that I would not repeat in similar circumstances. Anyway, the clear message to me, I had no future at the bar," unquote. Apos was unanimously absolved by the full committee of the Bar Council. In dismissing the charge, the presiding silk, Louis Vumard, said, quote, "What this bar needs is more Phil-Aposes, not one less," unquote. However, he'd had enough and he left the bar after nearly 5 years. He left the bar for nearly 5 years. By and large, though, we are lucky in this country that lawyers will rarely suffer such consequences because they've defended an individual's human rights. This consequence can be a common occurrence in some states. Samuel Lubitz, to whom I earlier referred, was faced with constant threats on his life during his trial and was regularly surrounded by state troopers for his own protection. A more recent example is Karina Moskalenko, a prominent Russian human rights lawyer and defender. In April 2000, a motion was issued by the Prosecutor General's Office to the Russian Registration Service seeking to disbar Ms Moskalenko from practising law. At the time, she was representing Khodorkovsky, a businessman and Russia's most prominent political prisoner, in a complaint to the European Court for Human Rights, in which he complained that his right to a fair trial had been violated. The attempt to have Ms Moskalenko disbarred prevented her from attending hearings on a defence appeal against a court ruling to extend her client's custody. The International Commission of Jurists is reported as having called on the Russian prosecutors to stop pursuing Moskalenko, describing the campaign to have her disbarred as nothing but harassment. Similarly, the United Nations Special Representative for Human Rights Defenders made representations to the Russian government expressing similar concerns. In June 2007, fortunately, the Moscow Bar Association refused to disbar Ms. Moskalenko. These are just a few examples of lawyers who, for doing no more than their duty, risk personal consequences over and above the stress of doing the work. The reports of Hina Jalani as the Special Representative of Human Rights Defenders describes countless cases of intimidation and abuse of criminal defence lawyers, ranging from violence, persecution and obstruction in countries like Zimbabwe and China to death threats and assassinations in places like Iraq and the Philippines. Even in places where criminal lawyers are not subjected to such harassment, in addition to the stress of doing their work, there is always the pressure that is applied to criminal defence lawyers by the public debate which surrounds some cases. So long as a fair trial is not affected, public interest in and discussion about these cases is important. There are particular cases which always attract public interest. They will often be cases which appear to demonstrate callous and brutal violence, usually involving defenceless victims. The cases are emotional. Members of the public looking on now see on their television screens the distraught families of both sides of the process. Inevitably, people pose to themselves the question, how would I cope with such a trauma? Perhaps it has always been the case, but the manner in which we deal with those accused of crime in our courts seems now to me to be a very tense issue. It is one that the community is very interested in, and rightly so, and one about which there are strongly held opinions. My observations of juries over 35 years leads me to believe that if members of the community are given good information about how the justice system functions, they will come to understand it, and in particular understand its importance and the importance of the individual rights that those charged are entitled to exercise. They do, I think, understand that the community itself is judged by the fairness with which we treat such people. The debate is polarised to some extent by the inevitable tension between the plight of victims in criminal cases and the fair trial of an accused. Ease of access to information through the electronic media means that everybody has a view, and that is appropriate. Courts, as a third arm of government, are not immune from criticism. Those lawyers who defend individuals charged with crimes are likewise not immune from criticism. However, in a recent article in The Australian on the 31st of October of this year, Professor David Flint, Emeritus Professor of Law and former Chair of the Australian Press Council and the Australian Broadcasting Authority, has expressed the view that the criminal justice system now functions more in the interests of the criminal, note, not the alleged criminal, but the criminal, than the great mass of law-abiding citizens, quote unquote. I'm afraid, with respect, he is simply wrong about that. The system functions in the interest of the community. Lawyers are said by Professor Flint to favour an imbalance, not because they want a fair trial for their clients necessarily, but because, he suggests, they have a vested interest in preserving the system. One can only wonder what kind of vested interest a defence barrister on legal aid rates, who's paid only for a portion of his work, might have. Professor Flint, in the course of his argument, underpins the argument by reference to, quote, public expectations, unquote, although he never quite identifies what they are, and then quotes a senior New South Wales prosecutor as follows, quote, there seems to be a fashion among some in the criminal justice system for a kind of misplaced altruism, that it is somehow a noble thing to assist a criminal to evade conviction, unquote. This carries the unfortunate and wrong implication that the criminal defence lawyer, whose job it is to ensure their client is given a fair trial, has some independent responsibility to make their own judgment about the guilt of their client and then act according to their own view. The responsibility of all involved in the process is to ensure that every accused person receives a fair trial. As juries are often told, the criminal trial is not a search for the truth. The question they must always consider is whether the prosecutor can prove his or her case against an accused person beyond reasonable doubt. If they can't do so, an acquittal must follow. A fair trial, of course, does not necessarily mean a verdict of not guilty. Fairness simply deals with the basic concepts of requiring the prosecution to prove its case beyond reasonable doubt and giving the accused a fair opportunity to test that case and be heard in his or her defence. There is a wide misconception which is fuelled by some commentators, some of whom are lawyers, which, as I have said, tends to have a polarising effect on the community. The misconception is that one is either for the rights of victims of crime or for the rights of the accused. You are one or the other. Judges, it is claimed recently, pay insufficient attention to the rights of victims. Again, with respect, I have to reject the suggestion. There is always, as I've said, a tension between what sentence a victim would understandably wish to see imposed on an accused and what sentence is actually appropriate, considering what both the statutory law and the common law require. The tension was beautifully identified by Justices Teague and Calvary when they spoke at ceremonies marking their retirements from the court. They would miss the court and the work of the court, they said, but what they would not miss would be the sad eyes of mothers looking up from the body of the court, mothers of victims wanting justice, and mothers of accused persons and prisoners wanting mercy. Judges are often accused of living in some form of unreal cocoon, away from the realities of life. Well, let me tell you that in the Criminal Division of the Supreme Court of Victoria, we deal every day with the unfortunate realities of life. We deal with accused people charged with murder and other offences. We deal with victims and witnesses. We deal with the desperate and the displaced. We deal with police, we deal with prisons, and we deal with prisoners. And we deal with the futures of many of those participants. On a day-by-day basis, we do the community's business each day. It is very real. The court, criminal court, I can tell you, is no cocoon. So for me, this has been, in many respects, a trip down memory lane. Over the last 7 years, since the 11th of September 2001, I have had cause to reflect on the importance of those who will stand out against the pragmatists and those who would label a group of people less deserving of equal treatment in the criminal justice system. The criminal justice system is a system of human rights. Nowhere else in the court system are common law or statutory rights more important. Whatever the shortcomings of the criminal justice system are, it is superior to so many other systems in the world, many of which I've seen. And that is because, at least in part, lawyers of the calibre of the people that I have mentioned have understood what is at stake and have defended it in the face of considerable political, social criticism and condemnation. The thirst of some for vengeance and retribution is probably stronger now than it's been for some time. It is the criminal defence lawyers who have to confront that attitude. They are the ones driven to constantly remind us that we can measure our civilisation and our humanity as a group of humans by the way we treat the most reviled members of our community. The people to whom I have referred are some people whose principles and commitment I have long admired. They represent hallmarks by which we, as the servants of the law and the community it regulates, should measure our commitment and courage on these issues. They would agree, I'm sure, with the sentiments expressed by former US Supreme Court Justice Robert Jackson, who left the US Supreme Court to prosecute the trials at Nuremberg after the Second World War. In his opening address, he said this: "We must never forget that the record on which we judge these defendants today is the record on which history will judge us tomorrow. To pass these defendants a poisoned chalice is to put it to our own lips as well. We must summon such detachment and intellectual integrity to our task that this trial will commend itself to posterity as fulfilling humanity's aspirations to do justice." Thank you very much. Yep.